रबर कंपनी होती तिने सिमिलर कंपनीला काय पैसे द्यायचे, पण 1960 मध्ये काय आलं की ते वर्ल्ड वॉर हे होतं, त्याच्यामध्ये सिमिलर कंपनीने असं हे केलेलं की
कोणत्या इयरला केस फाईल केला, विच इयर?
1960
मी तिघांनी डिसाईड करून मला एक सांग.
100% 1960.
1960 is the first World War.
1960 was the first World War.
1960.
As per my knowledge, the first World War started in the year of 1940, 1914, ended in November 1918. Second World War started in 1938, and in 1946. आणि तुम्ही 60चं सांगता, वर्ल्ड वॉर कुठे आहे त्याच्यामध्ये?
जर्मन कंपनी, जर्मन होती, एनिमी कंट्री होती, तो वर्ल्ड वॉर त्याच्यामध्ये नाही आहे. पण
जस्ट लाइक यू यूज द वर्ड वर्ल्ड वॉर.
I spoken world war, but actually that German company was an enemy company with England. So that familiar company, what his argument was, we can't make a payment to the continental rubber company. And
my cost. What is the facts?
Wadala company was a German company from England.
47
shareholders were German.
There is a
Shareholders were German.
internship certificate.
And director also German. And head secretary was London citizen. And Continental Rubber Company wishes to make the payments to the Daimler Company for the goods provided. For that, the Daimler Company filed a petition, which was rejected by the lower court. Hence, the petition was filed again before the House of Lords, which was the highest court of appeal and
Who is the opponent party? Who is the opponent party? This case. What is the final conclusion? 5 साल कसे झाले? 2 months. What about you? Was still continuous. आहात ना तुम्ही सगळे? What about you? What? How many years? How months? 3 months. कुठे? कुठे? बाबा मी काय बघायला पुढे जाणार. This is the lack of confidence. You have taken the certificate from a next.
Now the 498 is a suo motu. It is a suo motu. How you define the suo motu? 30 seconds. Yes, बोलिए. That's absolutely right. When in emergency. So can you say in the matter of the Nirbhaya, it was a suo motu or legislative procedure? Exactly. The same thing is why 498 was inserted in CIPC. The reason behind was Hundabadi was prior to the act, right? But then after when the various complaints come, so this you must remember while answering. So many complaints come to the court and then court take the suo motu. So what is 498 is a Hundabadi. Now what is 498A? Why they required to insert 498A? Hundabadi become a profession for the police and for the bride. Because they start harassing the bridegroom and his family people. Just like ये अपना कौन सा है मैंने नाम भूल गया, तो उसमें कैसा है किसी को मैंने हरिजन बोल दिया. So then what happens, you know, he started complaining. So ये पुलिस वाला और वो हरिजन दोनों ने मिलकर मेरी बैंड बजानी शुरू कर दी. So same thing. Same thing happens in the 498. So government Supreme Court inserted unless and until it is verified and proved, the section 498 should not be applied. First they have to verify and certify. So that is 498A. Okay, fine. Define temporary.
So temporary is for a limited period. This like it is type of the injunction,
Right.
and permanent is for indefinite period.
Okay. And what is the I mean to say in permanent? What sort of conditions court allows? 68.
So it depends upon the case, sir.
For example, any case you can quote it. Now suppose if it is a house breaking,
Yes, sir.
so what will
मध्ये क्रुएल्टी जास्त असते.
हा.
शारीरिक मानसिक छळ केला जातो
बरं.
आणि पती बरोबर त्याचे घरचे पण छळ करतात. ते 498 मध्ये क्रुएल्टी त्यामध्ये असते.
हा.
तर 498 मध्ये फक्त हुंडा मागणे, हुंडा देत असेल तर मग मारहाण करणे, छळ करणे.
So 498 is domestic violence and 498 is enticing a married woman.
Should I correct you?
Yes, sir.
तर मॅरिड वुमन ना पतीच छळ करतो.
But if somebody else's married wife, not your own. That's
498 is no problem.
Very good, very good. See, all of you are absolutely right from your own angle, but from the exam point of view, all of you are failed. बात समझ में आई?
somebody else's.
Anyone, immediate start. Don't waste time.
We are from the appellant side of Harminder.
देखो मारामारी करनी है यहाँ पे.
हाँ.
मारामारी करने के सोच से आने का अपेलेंट और डिफेंडेंट. चलो बात करो.
The issue before the Supreme Court whether the Section 9 of the HMA Hindu Marriage Act is constitutional or not. This is the main issue before the Delhi High Court. I think we are from the appellant side. I think HMA of the Section 9 of the HMA is unconstitutional. Because
So, you being advocate, don't say I think. You have to say yes, as per the section Hindu Marriage Act, this is section 9 is wrong, not applicable. This section.
because in Constitution, Article 14 and Article 21, Article 14, right, equality before the law, and Article 21, personal liberty. They say about the whatever. हम जहाँ
Yes, immediate start. Yes, what do you want to say? Article 9, 14, 21. Yes, you argued out immediately.
Correct, sir. These are the fundamental rights, but we are responding for this that we are focusing on the section 109, and this is restriction.
So don't say we, I focus on that, and my statement is like that. Okay, fine. Start.
But the Constitution is the supreme law of this country. Any law infringes the Constitution. That law is a ultra virus. It's executed from the that sections, law, anything.
So, constitutional supreme law, but you might have to different.
Speak loudly.
They have agreed, this both the couple have agreed to solemnize to be married, and they are agreed to act as a husband and wife.
Sir,
So, it
but-
should not come under.
Sir, wedding is
Yes, this is how it should be. Come on, start immediately.
Wedding is a kind of a contract which is in Hindu marriage act. It is not an actual contract, but it is a contract between between two persons. Okay, these two persons have their own personal life also, and constitution is there. Fundamental rights are there to protect their personal fundamental rights. Therefore, this section 9 of HMA should. तुम्ही काढून झाला त्यांचे
These are the constitutional rights, basically.
No, it's not constitutional. It's a legal right. It's a legal right.
Correct.
It's legal.
But as per the constitution, having a own, we have the right to choose my under the freedom of religion. So freedom of religion is my fundamental right, and the religion says that execution of conjugal right, these rights provide me from the religion. Basically, we protect these rights under the head of Hindu Marriage Act.
But sir, I wanted to object to it. This HMA is related to the person who are practicing Hindu or Sikh, Isai and Buddhist religions. What about the other religions? There is a discrimination between two religions. This particular section should, what I wanted to say, if this particular section is going to be a constitutional section, it will be applied to each and every person who in the country. Like fundamental rights are equal for everyone, whether he is from any other caste or any religion. This section of Hindu Marriage Act is related to a particular part of a community. So therefore, this is our defense for neglecting section 9 from HMA, because it is considered as, and I consider it as a
Basically, the main reason behind this is that what I think is that basically they want this law, this right explains us that having a married life and everyone has a duty to perform the marriage, and we are focusing on that. This marriage should be as per the law, and it should not violate the section.
आर्टिकल 19 जे फंडामेंटल राइट है त्याला ओव्हरऑल त्यामुळे सुप्रीम कोर्टने तिथे सिटिझनच्या बाजूने
31 प्लीज काय
बोलिए प्रेयर idea 33 yes
बोलते जाओ
सर पेयर मीन्स सर जो डिसिप्लिन का बात है
नहीं
33 ना फिर बोलो
rest of the thing. I am not interested in that. If you are talking about this code, this belongs to international question. Which code?
संजय यादव
मग काय प्रिपरेशन केलं तर वर्णन सांगू शकतो
आम्ही मागापासून तुम्हाला सांगता साईन करू नका इथे आमच्याकडे सायनिंग टॅली कसं होणार आता बसा सोनाली
verbally देख के नहीं बोलना है. What have you observed in criminal and civil procedure? And when you went to the court, which case was going on? Which type of case was on the board? चलो देखो उसमें से देखे फटाफट start with it. It means this is all copy paste. It is not fact. Start with it immediately. Speak loudly.
proceeding offer a valuable access to the functioning of the Bombay High Court Service site and learn the significance of procedural negligence, the consequences of non-compliance, and the practical steps advocate take to safeguard the client interest. The case recalls the importance of.
What was in the civil case? You are referring civil or criminal? Civil. Okay. What about the criminal? Start with yes. Immediately you start. कोई भी जितना तैयार है immediate start करो.
Criminal case which I referred.
बैठ जाओ तुम बैठ जाओ.
Which I referred. क्रिमिनल केसेस में मैंने जो देखा था मैजिस्ट्रेट कोर्ट में गया था तब मनोज कुमार वर्सेस स्टेट चल रहा था तो वो उसमें सीआरपीसी के सेक्शंस का अकॉर्डिंग में चल रहे थे 190 सेक्शन नंबर 193.
What was in criminal? Civil.
सिविल में सिविल सेक्शन में सिविल ट्रायल प्रोसीडिंग एज पर द सीपीसी प्रोसीजर चल रहा था. So that's why both section which include their section number.
Yes, next, get ready. Get ready, start immediately. All of you get ready, one after the other. Speak loudly. You are referring civil?
Yes.
So what about the criminal? Keep ready for the civil, then after criminal.
Examiner documents directed by merits.
How do you define the examining the documents?
I think by verification.
Okay, fine. Yes. Next start.
The civil case which I am referring is Arun Mutual versus Union of India. So in this case, the government of India has passed the Surrogacy Amendment Act and pursuant to this act.
What about the criminal?
The criminal was State Maran versus State of Tamil Nadu. In this case, the petitioner, the applicant was.
Yes, next. Speak loudly.
The civil case I am referring is of cooperative housing.
ऐसे खड़े रहो ताकि वो.
The civil case which I am referring is of cooperative housing society, and there I have observed how to file with technicians, how to draft notices, and.
Okay, fine. Next.
Which is referring about the civil cases, global tech innovations versus tech innovations, in which the case of arbitration was there. During the COVID period, that the particular period that there were no transitions that they demanded for their patent amount for which they have given for their particular period.
Criminal.
The criminal case was of Shruti Talwar versus Director of Enforcement, in which sections 45 of the PMLA was challenged, and Shruti Talwar was arguing for that.
Yes, next.
The civil case which I am referring to is Oriental Insurance Company Limited versus Ramesh Kumar Patil and others. The proceedings observing were the hearings began with the learned counsel for the appellant, Advocate Prashant Kulkarni, presenting arguments challenging the tribunal's computation. He contended the monthly income adopted by the tribunal.
Start next topic immediately. What is IC?
हम लोग जज को भी प्रेयर करते थे हमें अच्छी तरह न्याय दे इसके लिए प्रेयर सर.
अच्छा तो ये जो मैटर मेमोरियल में है वो प्रे करने के लिए रखा है क्या
सर? इसके लिए हम आर्गुमेंट्स करते हैं.
व्हाट इज द प्रेयर इन योर मेमोरियल 1?
Memorials, appearance and responded.
Tell me your prayer number 1 in your memorial.
In memorial in Muhammad Ali.
देख के बोलो किताब में से देख के बोलो तुम्हारा जो तैयार किया हुआ है ना.
Please tell me your memorial in respondent side. Prayer 1. Yes, yes, जल्दी बोलो.
Sir, my assistant is मुझे appear याचिका करता जो है वो मोहम्मद अली है. मोहम्मद अली ने जो याचिका करती है उसकी वाइफ के खिलाफ याचिका करती है. उसके वाइफ के साथ उसने शादी और दोनों लिया भी है. उनको 3 लड़के और 2 लड़की है.
मराठीत बोला.
3 मुले आणि 2 मुली आहेत. पण त्यांनी दुसरं लग्न करून पहिल्या बायकोला न सत्ता सोडचिठ्ठी दिली. त्याच्यामुळे त्यांनी कोर्टामध्ये त्यांनी शर्यतच्या मार्फत तिने तलाक दिला आणि त्या अनुषंगाने ती कोर्टामध्ये पोटगी मागण्यासाठी गेली. त्यावेळेला प्रथम न्यायालय प्रथम या दंडाची त्यावेळी तिला 25 रुपये अशी पोरगी दिली आणि ती पोरगी दिल्यानंतर तिचं 5 मुलांमध्ये ती पोरगी तिला मान्य नव्हती म्हणून ती हायकोर्टामध्ये गेली. हायकोर्टामध्ये अनुच्छेद 125 127 3B च्या अनुषंगाने तिने ती पोरगी मागितली आणि ती पोरगी कोर्टाने मान्य केली. पण मोहम्मद अलीचं त्याच्यामध्ये समाधान झालं नाही, कारण त्याचं म्हणणं होतं मी ना शेतीच्या मार्फतातून मी जी पोरगी दिलेली आहे ती पोरगी बरोबर आहे.
व्हॉट इज द अमाउंट ऑफ पोरगी?
179.22 रुपीज.
मराठीत सांगा ना तुम्ही.
179 रुपये 22 पैसे.
आणि कोर्टाने किती डिक्लेअर केलेलं आहे ॲज पर द हायकोर्ट ऑर्डर? उच्च न्यायालयाच्या आदेशानुसार किती अमाउंट डिक्लेअर झालेली आहे?
179 रुपये 22 पैसे. हायकोर्टाने
सध्या मग तुमच्याकडनं किती दिली जाते?
179 रुपये 22 पैसे दिले जाते. पण मोहम्मद अलीचं त्याच्यावर समाधान झालं नाही. ते म्हणतो माझ्या ही पोरगी जास्त आहे म्हणून त्यांनी सुप्रीम कोर्टामध्ये त्यांनी याचिका दाखल केलेली आहे की माझी पत्नी नाही आहे, कारण मी